Who killed Tara Baker? Obviously, by now, ladies and gentlemen, you know that's what this case is about. But before we get to know who killed Tara, it's important to know a little bit more about her. Tara Louise Baker was a bright, young, 23-year-old from Lovejoy, Georgia. And when she woke up on the morning of January the 19th, 2001, she had her whole life in front of her. She was a first-year law student here at the University of Georgia, and she had a wonderful circle of family and friends. Ladies and gentlemen, the next day, Saturday, January the 20th, it actually would have been her 24th birthday. And in the early morning hours of January the 19th, 2001, Tara's promising future came to a violent and abrupt end. She was sexually assaulted. She was stabbed. She was strangled. And she was left for dead on her bedroom floor. Her bed was set on fire. A fire, ladies and gentlemen, that smoldered for a considerable amount of time before it finally erupted through the roof of the house that she shared with two friends at 160 Fawn Drive here in Athens, Clarke County. On that morning, Tara's life ended. And what started was a 2.5-decade-long saga that has hung over the Baker family and hung over this entire Athens community like a specter. Ladies and gentlemen, this trial represents the final chapter in that tragic saga. The chapter where the state will prove to you, beyond a reasonable doubt, that the defendant, Edric Faust, is guilty of extinguishing the bright light that was Tara Louise Baker 25 years ago, where the state will show that he is guilty as charged of the crimes in this indictment. So you've heard the indictment a few times by now. Judge Lott read it in its entirety at the beginning of jury selection. The judge also just went briefly over what the charges are again here this morning. I'm not going to spend too much time going through the indictment itself right now. There will be a time and a place for that at the end of the trial. But again, ladies and gentlemen, you know now that the defendant, Mr. Faust, is charged with 12 counts. Count 1, malice murder. Counts 2 through 5, felony murder. Count 6, burglary. Count 7, aggravated sodomy. Count 8, rape. Count 9, aggravated assault. Count 10, aggravated sodomy. Count 11, arson in the first degree. And count 12, possession of a knife during the commission of a felony. All those charges stem from the morning of January the 19th, 2001. And I expect that that's going to become clear over the course of this trial. Ladies and gentlemen, these are obviously heinous crimes. And in order to prove them, and to prove that the defendant is the person who committed them, the state is going to have to present some very grisly evidence. And that's going to come in the form of both testimony and photos. Ladies and gentlemen, some of this trial is going to be difficult. But it's unfortunate, but it's necessary. I just wanted to give you a heads up. On January the 19th of 2001 at 11:22 a.m., Athens 911 started receiving telephone calls in the area of Deer Park regarding a fire at 160 Fawn Drive. Now, if you're not familiar with Deer Park, just to give you a little bit of reference, if we head, make sure I've got my orientation right, down Lexington Road, away from downtown, heading out towards Oglethorpe County. When you get past, Gaines School, Tuxton United Methodist Church is there on the left, right off Lexington. And the road immediately past Tuxton United Methodist Church, before you get to the Walmart, is Cooper Road. So again, heading that direction from downtown, left on Cooper Road, past the church. And then actually Deer Park, which is where Fawn Drive is located, is just on the right. And so when they get this call at 11:22 in the morning, the fire department is immediately en route. The firefighters actually kick in the door, the front door to Tara's house, because it was locked. And when they did so, they encountered smoke in the main living room area of the house. And I'm going to, in just a few minutes, not yet, going to be able to show you what the inside of that house looked like. So these firefighters kick in the door, and the first thing that they notice, apart from the smoke, is back in the right corner, which is where the kitchen is located. Through the smoke, they can actually see the eyes of the stove. It's one of those old school stoves that has the circular heating element. They can see those glowing red. And so through the smoke, they go over there to the stove. They realize that the knobs that would turn on and off those eyes have actually been removed from the stove itself. And so the firefighters put those knobs back on and turn the stove off. They open the back door to the house to ventilate, to help start getting the smoke out of the room. To this point, I don't think they've completely ascertained exactly where the fire was coming from. The back left bedroom of the house, and there's actually a bathroom door right next to it, it'll make sense in a few minutes, are closed. And so they go over there and they kick those doors in as well. And when they kick open that bedroom door, they are immediately met with flames rushing out over their heads. Firefighters enter and extinguish that fire. And in that moment, ladies and gentlemen, they discover Tara. She's naked. She's in between the mattress and the footboard to her bed. The footboard had been ripped away from the bed frame itself. So she's in that little V-shaped space in between. They notice a computer cord, what appears to be a computer cord, is wrapped around her neck. And so realizing what they've seen, the firefighters back out and turn the scene over to the police. And law enforcement does arrive. And so what we have here, ladies and gentlemen, is a sketch made by Athens Clarke County Police as to the interior of 160 Fawn Drive. I won't spend but a couple minutes going over it. The front door here is at the bottom with the arrow pointing up. Again, you see the kitchen in the back right with the stove, which is what the firefighters reported seeing glowing red when they came in the door. And what I want to focus on is what's in the top left of that diagram, what is referred to as bedroom 3. That was Tara's room. And you can see bedroom 3 has a bathroom connected to it, and then there's a door leading both from the bathroom, a door leading to the living room, and one leading into Tara's room. So that's the basic layout of 160 Fawn Drive. You can see there's a back door, which again has the arrow pointing down. And right next to that is a window that is situated right above their dining room table. You're going to see photos that will also help kind of explain the layout of 160 Fawn Drive. So that's the house as a whole. And this is Tara's room as the police encounter it. And again, I've tried to explain, but I think this does a better job showing exactly the orientation of her body inside that bedroom in the back left of 160 Fawn Drive. So again, you can see the footboard having been ripped away from the frame and her body lying in between. So upon arrival, Athens-Clarke County Police starts processing the scene. I expect you're going to hear from a number of witnesses that Tara's body, despite having obviously been in a room that was consumed by fire, her hair was actually still intact. I expect you're going to hear that several witnesses actually recall the smell of shampoo still coming from her hair. Again, there was a printer cord wrapped around her neck. I believe the printer itself was there in the room. And there's one thing that the police noticed that firefighters hadn't, was that Tara actually had a stab wound to the right side of her neck. And I think it was on the diagram. The knife was right underneath her body with blood on it. Officers also noticed a clock on the wall in Tara's room. That clock had stopped at 9:32. In processing the scene, officers noted that it appeared as if the doors and windows had been wiped clean. There's a screen to the back, that back window, the one that's right next to the back door, that showed signs of having been tampered with. Now, I expect there's probably going to be some confusion about exactly where that screen was when the firefighters arrived and when law enforcement arrived, but we'll get to that. Ladies and gentlemen, at 160 Fawn Drive, I submit that the evidence is going to show that any physical evidence that could have conceivably been helpful was collected. As an example, I think you're going to hear they even took the drain assembly out of her bathtub. A little bit more about the fire. I expect you're going to hear evidence that the bed, Tara's bed, was the source of that fire. And a little bit more, actually. I expect you're going to hear that there was a blanket that had been in the living room on the back of a recliner. That blanket had been removed from the recliner, taken over to the stove, set on fire, and then thrown on Tara's bed. I expect you're going to hear that there's actually still some remnants of that blanket on the stove itself. In learning about the processing of the scene, I expect you're also going to hear that there were no fingerprints of any evidentiary value that were taken in the house or off of Tara's body. I expect you're going to hear that hairs were collected from her body and from her room. And I also expect you're going to hear that her laptop was missing. The next thing I want to talk a little bit about, ladies and gentlemen, is the canvass of the neighborhood. By canvass, I mean police getting out and knocking on doors and seeing what, if anything, people had seen that morning. That was obviously done in this case to a significant degree. I expect you'll hear one witness recalled seeing a white male running in the area, open area behind Tara's house and near Tara's house around 7:45 that morning. I expect you're going to hear multiple witnesses talk about describing a black male with an orange shirt or sweatshirt at various places in Deer Park around 8 o'clock to 8:15 that morning. I expect you're going to hear one witness who described smelling a faint odor of smoke as he was leaving for work around 8:40, 8:45 that morning. At the time, ladies and gentlemen, there's just not much to go on as it related to that canvas. The next thing I'd like to talk about is the autopsy. Tara's body was taken over to Atlanta to the Georgia Bureau of Investigation's Department of Forensic Sciences the next day, Saturday the 20th, her birthday. And an autopsy was conducted by a medical examiner named Dr. Andrew Falzon. And here's where the evidence I submit maybe get kind of difficult. There were photos that were taken at that autopsy. And you're going to see some of those photos when Dr. Falzon testifies. It's going to be hard. You're going to see and hear about contusions surrounding Tara's vagina and anus. You're going to hear that stab wound that the officers noted when they got in to her bedroom had actually severed her jugular vein. You're going to hear about the ligature mark that was encircling her neck, and that her hyoid bone, which is a bone in your neck, had been broken. You'll hear about a subarachnoid hemorrhage to her head, which is indicative of blunt force trauma. You're going to hear about defensive wounds, defensive type wounds to her hands. Dr. Falzon, after conducting the autopsy of Tara Baker, listed her cause of death as ligature strangulation and a stab wound, with another significant condition being blunt force trauma to the head. He ruled the manner of death, obviously, a homicide. As part of the autopsy, a sexual assault kit was taken, based on the way Tara's body was found, based on Dr. Falzon's observations. So a sexual assault kit involved oral, vaginal, and rectal swabs of Tara and smears that were created based on those swabs. And I expect over the course of this trial there's going to be a great deal made about how one of those swabs was mislabeled. I expect the state's going to be able to clear that up as this trial unfolds. As part of the autopsy, head hair and pubic hair was retained, and fingernail and toenail clippings were taken. The next thing of significance that I'd like to talk about is some of the early forensics that were done in connection with this case. You're going to hear from Jennifer Corsi. At the time, back in 2001, Ms. Corsi was a forensic biologist at the GBI Crime Lab. She actually now works at the U.S. Army's Criminal Investigation Laboratory. She made a career out of this type of work. Ms. Corsi is the one who actually did chemical testing on that sexual assault kit, the one that we just talked about. You'll hear that her testing failed to reveal the presence of any seminal fluid, and that she took microscopic examinations of the vaginal smears and observed no spermatozoa or partially intact spermatozoa. And so, ladies and gentlemen, based on the existing technology and the existing protocols in existence back in 2001, there was nothing further that could be done with that sexual assault kit. I expect you'll hear that Ms. Corsi, then Fincher, so if I use both names, please forgive me, did confirm that the blood on Tara's fingernails, the only DNA in that on those fingernails belonged to Tara, that there was blood on the knife, and the DNA from that blood also only belonged to Tara. And there was no blood on the toenails that were taken. Not necessarily Ms. Corsi, but other forensics going on in the early days of the investigation. There were attempts to obtain fingerprints of any sort of evidentiary value, nothing to go on. I mentioned the hairs. Submit to you there was nothing that would help in the investigation at that time. I'm going to shift gears a little bit and talk a little bit more about Tara. In January of 2001, again, she's living at 160 Fawn Drive. She had two roommates, Ashley Peavy, now Ashley Hall, Valerie Lowe, now Valerie Lang. And I say that because, again, I might refer to them as both. Just wanted to get out in front and explain why that might be the case. So the three of them, Tara, Ashley, and Valerie, had moved into 160 Fawn Drive in August of 2000. All three of them were in grad school at UGA, but pursuing different programs. You know that Tara, obviously, was studying law. I expect you're going to hear evidence about Tara's morning routine. If she had a 9:30 class, which I expect you're going to hear she did that Friday, property law class on the 19th, then she's a pretty early riser. Up around 6:30 in the morning. First thing she'd do is take a shower. Expect you'll hear she'd come out and eat her breakfast. Every morning, same thing, cheese grits. And she'd come out and eat those cheese grits, her hair's still wet. And then she'd go back into her room and sit on the floor in front of her bed to blow dry her hair. And that took a while, ladies and gentlemen, because I expect you're going to hear Tara had a lot of hair. I expect you're also going to hear about how Tara was trying to buckle down in January of 2001. As that new semester at the law school had gotten underway, she was spending less time at home and more time at the law library. But Saturday was her birthday. And on Friday night, she was going to go out and have some fun with some friends. They were going to go to the Winery, which is a bar downtown on Broad Street. I don't know if it's still there, but it was in 2001. But talk about Tara's last hours. Go through what we know about Tara on Thursday, January the 18th. We know that both Ashley and Valerie were leaving for the weekend. They were both leaving that Thursday. Ashley left late that afternoon. She and Tara had been at home together before Ashley left. We know that from approximately 7:30 to approximately 9:30, Tara was at the law library here on North Campus, not too far from the Arch. She's there with a friend named Katie Lonstein. Around 9:30 that night, Katie leaves, goes home. I think there was a discussion about, hey, call me when you get there, make sure you get home safe. And Katie indicated that she would do that, but she forgot. Why is that significant? Because Tara called her. Tara called her at 9:46 that night to make sure Katie had gotten home. And ladies and gentlemen, that is the last time that anyone is known to have spoken to Tara. Friday, again, January the 19th. I think it was kind of a cold, overcast, rainy day, kind of day that it seems like we've been having a lot of those lately. Again, expect you're going to hear evidence that the neighbor across the street smelled smoke, around 8:45 as he was going to work. Point out once again, Tara misses a property class that started at 9:30 that morning. The clock on the wall stopped at 9:32. And then again, ladies and gentlemen, 11:22 is when the fire is reported at 160 Fawn Drive. I'm going to talk a little bit now about Chris Melton. Some of you have heard his name already in jury selection. Chris Melton was Tara's boyfriend. You're going to hear a lot about the relationship between Tara and Chris leading up to January the 19th of 2001. What I expect that you're going to hear is this was a relatively typical relationship between two very busy people in their early 20s. Tara and Chris met when they both attended college at Georgia College in Milledgeville. It's now Georgia College and State University in the late 90s. Tara and Chris were introduced through mutual acquaintances and hit it off, and they began to date. When Tara graduated from Georgia College, she went back home to the Lovejoy area. And for those of you who don't know, Lovejoy is off of I-75 south of Atlanta. And she got a job at a law firm there. Chris didn't finish school. He also moved back home in with his parents as well. That's in Covington. When Chris moved home, his mom told him he had to get a job. And so he got one. Chris became a plumber. And so at this time, Tara and Chris are in a long-distance relationship because Covington, Lovejoy, about an hour and a half apart, maybe a little bit less. Tara moved to Athens, I believe in 1999, when she got a job at a law firm here in town. So at that time, Tara's in Athens, Chris is still in Covington, and so they're still kind of doing the long-distance thing, right? Maybe not quite as long, but certainly not in the same town. And they found it hard to find time to get together. And so Chris moved to Athens. He got an apartment with a roommate at a place off of Millage Avenue. And he was commuting back and forth to work. Most of his work was in the Loganville, Gwinnett County area. But I expect what you're going to hear is that Chris and Tara were trying to figure out how to have an adult relationship when they both had a work life and other things going on that they had to manage. As I mentioned before, Tara started law school in August of 2000. I expect you're going to hear that during that fall semester, that first semester, Ashley and Valerie are going to mention to you that Tara was spending a lot of time at Chris's apartment. Now, that doesn't mean Chris wouldn't come over to her house too. He did, maybe just not as often. But when they did, they'd spend the night at each other's house, both at Millage Avenue and at Fawn Drive. This is normal relationship stuff. Moving into the spring semester, January 2001. Now remember, Tara was trying to buckle down. More time in the library. Well, at that time, Chris also had good things going on. I mentioned that he had taken up plumbing. He was working for a company, but around this time, he started maybe thinking about going out and doing work on his own. You know, his business was mainly in the Loganville, Gwinnett area. And so at this time, you know, he's using his truck, not a company one. It's his gas, his time spent commuting, and if he's traveling back and forth from Athens to Loganville every day, he's not making money. And the reason why I point all that out, ladies and gentlemen, because I expect the evidence is going to show that at that time, Chris moved back in with his parents in Covington. So he could spend more time working and less time traveling to and from. Now, ladies and gentlemen, I expect that others might have thought that the relationship between Chris and Tara was starting to fizzle. Again, I think the evidence is going to show that this was just a relationship between two young people whose presents and whose futures were still being figured out, with some highs and some lows, but nothing out of the ordinary. In fact, I expect you're going to hear that Chris had gotten Tara a very sentimental Christmas present just a few weeks prior to her death, and it made her really happy. He was going to come to Athens Saturday to celebrate Tara's birthday with her. Chris saw the potential for a future between them. Others may have made assumptions otherwise. But the bottom line, ladies and gentlemen, is the evidence will show you that there is nothing to suggest their relationship was in a bad place. Let's talk about what Chris was doing on January the 19th of 2001. As I just got done explaining, he spent the night before, Thursday night into Friday, at his parents' house in Covington. And from 7:15 that morning until long after Tara's body is discovered, his whereabouts are accounted for. At 7:15 or thereabouts, a coworker named Josh McCurdy came over to Chris's house, or Chris's parents' house, to be clear. And Josh was with Chris all day. There's a brief period of time around lunch, 1:30 to 2:30-ish, where they were not together. 1:30, obviously, after the fire at Fawn Drive. But other than that, they were together all day. Made numerous stops throughout the day. You're going to hear a little bit about some of those stops. What I expect the evidence is going to show is that at 9:08 that morning, Chris went into a Wachovia in Loganville. Wachovia, for those of you who don't know, is now Wells Fargo. And at 9:12 that morning, he withdrew $480 from the teller. I expect you're going to hear about some visits that he made to a place called Truck Customs. Remember, Chris is starting, to do his own thing. He's got a truck. He's in the plumbing business. He needs a pipe rack. He needs a ladder rack. So he'd gone to this place called Truck Customs. First stop time, I think maybe around 10 o'clock. Second time later in the afternoon. And it's at that second trip to Truck Customs, ladies and gentlemen, where Chris gets a call from Tara's mother. Something's happened in Athens. You need to come over. Ladies and gentlemen, all those facts were established fairly early in the investigation. Now, you're going to hear about Chris's reaction when he got the call from Tara's mom about something happening in Athens, how Josh actually had to drive him in his own truck to Athens. And even with all of this, ladies and gentlemen, with those facts being established early in the investigation, Chris was always under the microscope as it related to Tara's murder. He was asked to give blood. He was asked to give a sample of his head hair. He was asked to give a sample of his pubic hair. Chris was subjected to repeated interviews by law enforcement. Every time anything's ever been asked of him, his answer's always been the same: whatever you need. The evidence will show that Chris has been fully cooperative for over 25 years. I'm going to try and move a little bit quicker now because I think I'm taking longer than I intended. But there is a lot of other investigation going on in this case, ladies and gentlemen. This is a 20-plus-year-old case. The state is not going to present to you everything that was done over the course of this 23-year investigation. From a period of time, several months after Tara's death in 2001 until 2024, we're going to talk more about that soon, there was a lot of work being done on this case. But there was nothing that would point the police in the direction of Tara's killer. There are tens of thousands of pages of police reports, records. There are hundreds of hours of interviews. It would take months to present all that in court, and we're not going to do it. And in so doing, we're not trying to hide anything. We're being mindful that it is an absolute impossibility to show you every lead that was chased down and every lead that became a dead end. About the dozens of persons of interest who were identified but ultimately ruled out. Hard work, frankly, just didn't result in any relevant evidence. One example, in 2010, the ligature, the printer cord, and the knife were retested for DNA. Not just the blood, to see if there was any touch DNA on those items. And once again, only Tara's DNA was found. I expect over the course of this trial, you're going to hear about some missteps and some unanswered questions. Remember that window frame I talked about earlier? Well, the window frame was obviously taken into evidence back in 2001, but now, 25 years later, it's missing. And that's unfortunate. But what is fortunate is that you're still going to hear about the processing of that window frame that was done back in 2001, and how, again, there were no prints recovered. You'll hear that Tara's laptop, the one that I mentioned had been taken from her room, has never been found. And lastly, as far as unanswered questions go, I'd submit to you the evidence can show that no one investigating this case has been able to quite figure out exactly how the defendant got in and out of 160 Fawn Drive. Was it the kitchen window with the frame that showed signs of tampering? Was it the back door? To this day, ladies and gentlemen, there's no definitive answer. And the state's not going to be able to show you the answer to that in this trial either. That fact is not necessary to prove the defendant's guilt. And so again, with all this investigation going on and no leads being developed, the case goes cold. Something happened that changed all of that in 2023. Something called the Coleman-Baker Act was signed into law by Governor Brian Kemp. In case you hadn't figured out, the Baker part of that act is named after Tara. This is a law designed to address cases exactly like this one, where all leads have been exhausted and no likely perpetrator has been identified. What the law does is it directs new eyes to be placed on the file. See if all appropriate forensic testing and analysis was done in the first instance, or if additional testing might produce evidence or information relevant to the investigation. And so at this point, enter into our story Agents Liz Bigham and Jeremy Howell with the Georgia Bureau of Investigation. Agent Bigham, Agent Howell are longtime agents with the GBI, and they joined that cold case unit after the law was enacted. In December of 23, they started looking at this case. And one of the first things they did was a dogged re-examination of all the physical evidence in Tara's case, including the sexual assault kit that had been taken at her autopsy. That kit was resubmitted for testing in February of 2024. And so, ladies and gentlemen, a lot's changed about DNA and the way DNA is tested from back in 2001. I expect you're going to hear that the sensitivity of that testing has improved greatly. And so, in February of 24, the crime lab was able to find first male DNA and then obtain a DNA profile from item 2I. It's going to get confusing. We can clear all this up later about the names of those items. 2I is labeled oral swab B. It's pretty confusing. And so, upon further testing of 2I, what they do is they separate the DNA into what's called fractions. I'm not going to get too much into the details of it now, but the idea is you're trying to separate the female DNA from the male DNA. 2I, the oral swab B, the first fraction is a match to Tara Baker. In the second fraction, there's a partial major profile of male DNA. And that DNA is not Tara Baker and is not Chris Melton. In case I haven't been clear, when I refer to a profile, what I'm, for lack of a better term, talking about is a DNA fingerprint. So when I talk about profiles, that's what I mean. But that profile, that partial major profile from item 2I was eligible to be submitted into something called CODIS, C-O-D-I-S. That stands for the Combined DNA Index System. CODIS is a national database of known DNA profiles. I think that as of November last year, there are about 26 million known profiles in CODIS. And once that profile from item 2I was uploaded into CODIS, the way it works is it is routinely compared against the 26 million known profiles to see if any leads could be developed. On April 30th, 2024, there was a hit. And it was that DNA, again, matched from item 2I, and that hit was to the defendant, Edric Faust. Ladies and gentlemen, that is the first time in 23 years and tens of thousands of pages of this law enforcement file that Mr. Faust's name shows up. So what do we know about Mr. Faust? He lived at 350 Cooper Road, and we talked about Cooper Road earlier. You can see it there. It's actually at the top of this picture. The star represents 160 Fawn Drive. I'll get more into that in just a minute. Cooper Road, again at the very top, going horizontally in the picture. If you were to go left on Cooper Road, that's where you're going to run into Lexington Road, just to give you some orientation. Mr. Faust is living at 350 Cooper Road. 350 Cooper Road, ladies and gentlemen, is literally 585 feet from 160 Fawn Drive. So, next, what happens? Agents Bigham and Howell obtain a warrant to get Mr. Faust's buccal swabs, cheek swabs. And the purpose of that is to get a known sample of his DNA. CODIS, only a lead, you got to confirm it. And again, the first fraction from oral swab B, Tara's profile, it's always Tara's profile, vaginal, oral A, oral B, we'll clear that up later. Always Tara's DNA in that first fraction. And in that second fraction, you're going to hear about there being two profiles, but the major profile, the partial major profile from item 2I was a match to Edric Faust. And that match, I might mess up the wording of it, was 1 in 800 quadrillion.
I have objection, Your Honor. And I have a motion.
All right, ladies and gentlemen, I'm going to have you go back into the jury room. Don't discuss the case. Thank you.
past this, there are going to be more slides that use the same type of language. Obviously, when it occurs, I'm going to get up and move for a mistrial again to preserve the record. But I would ask the Honorable Court to instruct the state to use accurate evidence that will come into, accurate descriptions of evidence that would come into evidence. This slide is not accurate. And the next two slides that involve true allele won't be accurate as far as the match language, Your Honor.
Anything from the state before I make a comment?
I disagree with every assertion Mr. Cruz just made.
All right, thank you. Mr. Cruz, your comment is, you used the word evidence. And I've already instructed the jury that anything said by the attorneys, including opening and closings and arguments by the attorneys, are not to be considered as evidence. This is not to be considered as evidence. It is part of the opening statement. I'm going to deny your motion.
Yes, ma'am.
Have you heard from them? All right. All right, very good. You can bring the jury out now. Thank you very much. All right, you all may be seated. Thank you. Mr. Bolden, you have the floor.
Thank you, Your Honor. As I was saying, 1 in 800 quadrillion. That is, if I got it right, an 8 followed by 17 zeros. That's not all that you're going to hear about as it relates to DNA testing that was conducted in 2024. You're going to hear a great deal about something called true allele. I am not going to go into it too in depth this afternoon, but basically, true allele is this high-tech software that uses something called probabilistic genotyping to decode very small or mixed samples of DNA from a piece of evidence. And again, I'm not going to go into all the nuts and bolts of true allele here because frankly I just don't think I'd do a very good job. But you are going to hear from Ashley Hinkle. Ms. Hinkle is a forensic biologist at the GBI Crime Lab who is an expert in true allele. She'll give you a good explanation of what it is and how it works. And ultimately, you're going to hear that all 3 swabs from the sexual assault examination of Ms. Baker were analyzed using true allele. Again, that same swab 2I, this is oral swab B. Again, the second fraction, separating male from female DNA. At least 2 individuals, we'll explain more later. Again, the major contributor based on the true allele results was Edric Faust. The way true allele reports, ladies and gentlemen, is that the wording is significant. It's called a likelihood ratio. What Ms. Hinkle, I expect, is going to tell you that the likelihood of a match between Mr. Faust and the partial major profile in 2I is 30 octillion times more probable than a coincidental match to an unrelated person in the population. 30 octillion. Again, if I counted right, that is a 3 followed by 28 zeros. So 2J is another swab that was collected at the sexual assault kit from Dr. Falzon way back in 2001. We're going to explain more about what 2J is throughout the trial. First fraction, again, Tara, always Tara. The second fraction of 2J had the profile of at least 3 individuals. There's a match to Chris Melton. Make sure I get it right. 30 octillion times more probable than a coincidental match. And there's also a match to Edric Faust. Likelihood ratio there.
Your Honor, I would renew my request, my objection.
Your motion is denied.
Yes, ma'am.
You may continue.
The match to Mr. Faust here is 70 billion times more probable than a coincidental match. Then also, ladies and gentlemen, you'll hear about true alleles analysis of the rectal swabs. Here, the second fraction had at least 3 individuals. There's a match to Chris Melton, a much lower number, 60,000 times more probable than a coincidental match. Going back, ladies and gentlemen, to 2J, the last one that I mentioned, it's a very important fact that I almost overlooked. Why would Chris's DNA be present in 2J? Well, I expect the evidence is going to show you that he and Tara had been intimate the weekend prior to her death. I expect that you'll hear that it is not uncommon for DNA to be found that far in the past, or when sex was known to have happened that far in the past. I expect you're going to hear that current guidelines for collection of evidence in cases like this is 120 hours. So that's 5 days. And again, Chris and Tara had been intimate the weekend before her death. So the rectal swabs, I don't want to spend too much time on it. Obviously, only Chris's DNA is found there. It's a very small amount. That's significant. You'll hear more about that later. Ladies and gentlemen, the evidence is going to be very clear that Chris and Tara were not engaging in anal sex. You're going to hear about a phenomenon known in the forensic community known as drainage. I guess an easier way to think about that is gravity. This is a known fact. Semen, just like any other physical object, is subject to gravity. And the vagina and the anus are in pretty close proximity. And remember how Tara's found in the floor of her bedroom. All right, so I'm nearing the end of our story. Armed with their investigation to this point, Agents Bigham and Howell interviewed the defendant. That took place on May the 9th of 2024, and it happened at the Athens-Clarke County Police Department. Mr. Faust had been placed under arrest for the murder of Tara. He was read his rights, and he agreed to talk with him. Now, I'm not going to go into everything that was said over the course of that interview. You're going to see and hear the relevant portions of that interview. But just a note, Mr. Faust said that he'd been living at 350 Cooper Road, off and on, for 40 years, to include the time frame back in 2001. 350 Cooper Road was actually his stepmother's house. During the interview, Mr. Faust denies ever dating anyone in Deer Park, ever knowing anyone in Deer Park, or that anyone from Deer Park ever came over to his house. All that was said in this interview before he was actually told what the charges were for. And you're going to see, frankly, during this interview, I think the evidence is going to show that this is pretty conversational nature between the defendant and Agents Bigham and Howell. And then at the end, they tell him what the charges were for. Agent Howell actually says, and he's referring to Tara here, "Don't you remember? It was kind of a big deal." Agent Howell offers, "If you can help us understand why your DNA is in that house, help us. I'm here to exonerate just as much as I am to hunt." And you'll hear the defendant's reaction. Ladies and gentlemen, at the beginning of my opening remarks, I talked about how this trial represents the final chapter in a long, sad saga for both the Baker family and for the Athens community. For decades, everyone who loved Tara wanted to know, who killed Tara Baker? Ladies and gentlemen, Edric Faust killed Tara Baker. Edric Faust sexually assaulted Tara Baker. Edric Faust set her house on fire. And now, the final chapter begins today. But the last few pages of this story haven't been written. At the end of the trial, we're going to hand you the pen, and you, the jury, will write those last few pages. And when you do, you'll have the evidence to write the correct ending to this horrible saga. Ladies and gentlemen, I didn't say the happy ending. That's not possible. The correct one. You'll have everything you need to know to write the ending that the facts support and that justice demands. An ending that finds, beyond a reasonable doubt, the defendant, Edric Faust, is guilty as charged. Thank you.
Counsel for the defense, opening statement.
May we use the monitors, please, Your Honor? My name is Attorney Ahmad Cruz, and I have the privilege and the honor of standing beside Mr. Edric Faust during this case. First and foremost, I want to thank you all for your sacrifice in taking time away from your families, your jobs, and your very important matters to sit and listen to the evidence the state presents in this case. We intend to get you all home as quickly as possible. Once you have all the evidence that you need to make a decision and not a moment before. First off, you can see on your screens, I'd like to tell you what happened. You all sat through 5 days of jury service, and no one ever explained to you what happened. Then we're going to talk about how this is a crime of opportunity, the evidence that you were here supporting that this is not, let me put it this way. You'll hear evidence supporting that this is a crime of opportunity. Then we'll get into Chris Melton's and Tara Baker's relationship and what the evidence will show there. That is going to be very important in this case to understand what was going on with Miss Baker and Mr. Melton before she passed. Then we're going to talk about then I'd like to talk about with you the initial investigation in this case. This investigation, when it came to Mr. Foss, that isn't the initial investigation, but this investigation, when it came to Mr. Foss, you may decide that this is one of the most thorough investigations in Georgia history. In fact, you will learn that this investigation reached a level of desperation. And at the end of this trial, you are going to have questions that the state is not going to be able to answer. And I believe during the state's opening, they admitted one, which is they cannot present evidence to you, or they cannot answer the question of how Mr. Foss would have gotten into Miss Baker's home. They also can't answer the question of when did Mr. Foss's DNA get in Miss Baker's body. They don't know. They won't be able to answer the question, how would Mr. Foss get away from Miss Baker's home unseen at the time of the morning that they said he committed this crime? The evidence will show that in Deer Park, black people simply walking were reported. In fact, on January 19th, 2001, the day Miss Baker passed away, there were two reported, but one person was reported twice. It was a black male. He had a afro, and he was wearing a bright orange shirt. And the witnesses say, hey, he's just walking normally through the neighborhood. Is he looking around suspicious? No. Is there anything unique about him? No. Actually, when I pulled out my car to get out the driveway, he stopped for me. So the state won't be able to answer if they're reporting individuals walking through the neighborhood. How did Mr. Foss get away unseen in the middle of the morning? And the last question that the state won't be able to answer for you. If Mr. Foss killed Miss Baker, why was the hair that was found on her body, around her body, in her hand, and on the murder weapon of Caucasian origin? You will hear evidence in this case that there is not a shred of evidence that puts Mr. Foss, let alone a black person, in Miss Baker's home. All of the evidence, including the gift Miss Baker left in her hand for police, it's Caucasian hair. Now, the state, these questions have to be answered with evidence, not speculation, not with sensationalized media coverage, and not with unsupported conclusions. These are questions the state must answer for you with evidence and proof. The state may spend a lot of time talking about Mr. Foss's DNA. That is not at issue in this case. DNA is not at issue in this case. But they may spend a lot of time talking about Mr. Foss's DNA being present among, as they presented to you, the multiple DNA profiles that were found and identified. But you may find yourself asking this question at the end of the state's presentation of evidence. How does Mr. Foss's DNA simply being in Ms. Baker's body, along with someone else's DNA profile, establish that he is the person that killed Ms. Baker? And this is why you all are here today. This is why we are here today. We're not here to talk about, and the state is going to present this type of evidence. We are not here to talk about how bad of a person Mr. Foss may have been, how horrible of a boyfriend he may have been. That's not evidence in regards to what they must present to you to prove that Mr. Foss is the individual that committed these acts that they've chosen to charge him with in the indictment. We're here to talk about and find out whether the state's evidence proves beyond a reasonable doubt that Mr. Foss committed the crimes that he's charged with. That's it. That is why we are here. And in this trial, the question is not who killed Ms. Baker. That is not the question that anyone is asking you to determine. But again, the question is simply, does the state's evidence that they present to you prove that Mr. Foss, proves beyond a reasonable doubt that Mr. Foss is the person responsible for burglarizing Ms. Baker's home? He's charged with burglary in the indictment, sexually assaulting Ms. Baker, and killing Ms. Baker. That's the sole question you have to answer. Not who did it, just does the state's evidence support beyond a reasonable doubt that Mr. Foss is the person that committed this crime. And that's the key issue in this entire case. And you may get distracted by emotion in this case. You may get distracted by your dislike of Mr. Foss's life choices. But you cannot lose focus, and you cannot forget why we are here today. You are here on a murder, a rape, an aggravated sodomy, and a burglary case. You're going to learn that this is not a case of stranger-on-stranger violence, but rather a case of interpersonal violence. Interpersonal relationship violence. But you cannot be distracted. You can't be distracted. The reason we all chose you is because we thought you were the best jurors to sit on this case. You would not be distracted by emotion, and you would let the law guide you and come to a just decision. The death of a person is a horrible, horrible tragedy, and no one in this courtroom would tell you otherwise. We are not the media. We don't have the opportunity to speculate and draw in viewers. We don't have the opportunity to sensationalize this case of Ms. Baker's life. And that's what we're going to talk about during this trial, is Ms. Baker's life. We're going to show you what Mr. Foss looked like in the year 2000. This is Mr. Foss in the year 2000. He looks completely different than he looks now. What we put an emphasis on, and what you'll hear in evidence, is this is how Mr. Foss carried himself. He was a very well-dressed, clean-cut individual. He wore jewelry. He drove nice cars. We expect the evidence to, we expect the evidence to show that. We're also going to show you a picture of Mr. Foss on February 8th, 2001, which is about 2 or 3 weeks after Ms. Baker's death. This is Mr. Foss about 3 weeks after Ms. Baker's death. Without a haircut, obviously, without his jewelry in, but this is a picture of Mr. Foss. And the evidence will show this is how Mr. Foss looked after Ms. Baker's death. In 2001, the evidence will show that Mr. Foss was a 25-year-old bar-hopping playboy. You will hear from some of Mr. Foss's ex-girlfriends. Particularly, the state will call Miss Brenda Sweeney. And you will learn in this case that the state, Miss Elizabeth Bigham, she will testify that she's reviewed every single document in this case file. And based on her review of that information, what you will learn is that Mr. Foss did not stay at 350 Cooper Road. Mr. Foss actually stayed in Knollwood Apartments with his girlfriend, Miss Brenda Sweeney, at the time. And this is information that the state has had before today and during the entire pendency of this case. So what happened? That's the question that we're here to figure out. What happened with Ms. Baker? This is Ms. Baker shortly before she passed. This is her law school photo that she took while she was a student at the University of Georgia. And these are Chris Melton's hands after Ms. Baker's death. So Ms. Baker was killed on January 19th, 2001. These photos were taken on January 21st, 2001. This is Mr. Melton's left hand. This photo, these are Mr. Melton's right hand. During this trial, you will learn the nature of Ms. Baker's death. It was an overkill. And what we mean by that, it was terrible. That's the best word I could use. It was terrible. It was a horrible death. Ms. Baker was not only unalived, but the person who did this to Ms. Baker, they beat her, they punched her over and over and over again. And you will hear from the medical examiner the injury she had to her face. Her eyes were swollen and blackened. And then this individual, we don't know the order, but this individual, this sick individual, then took Ms. Baker's printer cord and wrapped it around Ms. Baker's neck. And he laid on top of Ms. Baker as he pulled the opposite ends of that printer cord, strangling her. That individual, at some point, again, we don't know the order that this took place, but these are the things that took place. This individual at some point walked to Ms. Baker's kitchen, pulled out a knife out of her knife block, and then stabbed Ms. Baker in her neck. And you will hear that Ms. Baker was stabbed on the right side of her neck. This wasn't enough for this individual. This individual then went into the living room of the home, took Miss Ashley Hall's chenille blanket off of the couch, went and turned on the eye of the stove. They put the blanket on the stove, and when this blanket caught ablaze, what occurred was this person walked back into Miss Baker's room while Miss Baker laid on the floor, still grasping for air, and you will hear that there was shooting in her lungs. He places this blanket on the bed, and then this person takes your laptop, and you will hear back in 2001, laptops, cell phones now are like laptops. Back in 2001, laptops were like the cell phones. They would have all your personal information. But this person takes her laptop, he then closes her door, locks it, goes to her bathroom door, and you saw a picture of it in the state's opening, closes the bathroom door, locks it, and takes his time to clean up Miss Baker's house. As the state mentioned in their opening, this person wiped down the door. This person wiped down the stove handles. This person wiped down the back door. This person wiped down the windowsill. And when firefighters, obviously fired a couple of hours later, the fire burst through the roof, you will hear from firefighters that in order to get in this home, they had to kick in the door. And it was deadbolt locked. And the type of doors you'll learn that Ms. Baker had, the The top lock has a key that you can put in. You have to unlock it to unlock the deadbolt. The bottom lock from the inside, you can just twist it. They have to kick in the front door. It is deadbolt locked. And the back door, there's so much smoke, and the state said this in their opening, there's so much smoke in the house, the firefighter goes to the back door to unlock the door, and the deadbolt is locked on the back door. But what you will hear is that when firefighters found Miss Baker, the individual that did this to her, this was somebody she was comfortable being naked around. The state is not going to present any evidence that clothes were ripped off of her. The state is not going to present any evidence that clothes were found near her. The state's not going to present any evidence that a towel was around her. She was completely nude, no clothing around her body at all. Now, while this individual was strangling Miss Baker, you don't leave the life sentence or you bring your life sentence. The evidence we intend to present is that Miss Baker was scratching at this individual's hands while he was trying to strangle him. While he was choking him, Miss Baker was trying to get him off of her. While he was choking him, Miss Baker was grabbing his hair, trying to get him off of her. And the forensics evidence, and we'll get into the forensics, I won't go there now, but the forensics evidence will support that Ms. Baker was fighting for her life. Now, I mentioned the back door, that the back door was deadbolt locked. You will hear from a young lady by the name of Miss Kishana Armstrong. She's Ms. Baker's neighbor. Okay? Ms. Baker stayed at 160 Fun Drive. Ms. Armstrong stayed at 140 Fun Drive. So if you're looking at this map, Ms. Baker's home is here where the blue tarp is. Ms. Armstrong's home is right there, 2 houses up. And what Ms. Armstrong could tell you, and this is the same thing she told law enforcement 20 plus years ago that they ignored, was that, hey, it was 7:45 in the morning. I was going to my car because I had classes. I was getting ready to go to school. And to my surprise, I found it odd that a white guy was running through my backyard with a white T-shirt on and light blue jeans. And Ms. Armstrong is going to tell you, you'll see a photo of it, but Ms. Armstrong is going to tell you, she's going to testify. And what she'll tell you is this person, I can't remember the face because it's been 24 years ago. And you'll learn police never followed up with it. They never showed her a photograph of Chris Melton. And as the state said, Chris Melton was the center of the investigation, right? But they never showed her a photograph of Chris Melton. They never gave her a photo lineup. They said, hey, do you recognize anybody in this photo lineup? So what she'll come in and testify to is, hey, I don't remember the person's face. I can't really remember the person's hair, but I do remember the person having the exact same color hair as Chris Melton. That's what Ms. Armstrong is going to tell you. This is Chris Melton, back in 2001. Ms. Armstrong is going to tell you that she can't remember her hairstyle. She's like, I can't really remember her hairstyle. But I do vividly remember this person's hair color. And what you'll learn is police never even asked her the hair color. They don't even ask her. When they interviewed her 20 years ago, they don't ask her about the hair color. Only thing they ask her, how tall is the person? What age group does he look like he was in? And she'll say he looks like he was in his 20s. He had kind of like a medium athletic type of build. And they're aware that Miss Baker is dating Chris Melton. They never show her a photo of Chris Melton. You will learn in this case that law enforcement ignored Ms. Armstrong for 25 years. We had to reach out to Ms. Armstrong. Once Mr. Foss was arrested, Ms. Armstrong was no longer needed. Crime of opportunity. I told you that I would talk about how this crime is a crime of opportunity. During this trial, one of the most important facts that you all will learn is that Ms. Baker did indeed have two roommates. One of her roommates is Dr. Alibi. I believe you heard about her from the state. Then she went by Miss Valerie Lane, who's in school, and also Mrs. Ashley Peavy Hall. At the time of this case, in 2001, she went by Miss Hall. You will learn that each girl had a boyfriend, and we are counting Miss Baker and Mr. Miller. So at any given time, you will learn that there were 6 people in the house. And it was very rare, you hear testimony, it was very rare that someone would be at the house alone. However, on January 18, 2001, being great roommates, Dr. Lowe tells Ms. Baker, hey, I'm not going to be home. I'm leaving town. I believe she was going somewhere with her boyfriend, so she was going to be out of town. Miss Ashley Peavy Hall tells Ms. Baker the exact same thing. And you will hear testimony about Ms. Baker's response. What you will know is that Ms. Baker was home alone. What you will also hear is that Ms. Baker and Chris Melton spoke the day before her death 5 times. There was a 22-minute call. There was a 5-minute call. There was a 19-minute call. And there was 2 other short calls the day before her death between Ms. Baker and Chris Melton. And when law enforcement asked Chris Melton the day of the crime, or the day close to the crime, hey, did you know that Ms. Baker was going to be by herself? He said, of course not. He said, of course not. I didn't know that. She wouldn't have told me anything like that. But I do remember me telling her that I wouldn't be able to come down to Athens and spend the night with her. A couple of years go by. And police do this. This is a part of their investigation tactics. Police ask him again, hey, do you remember if Ms. Baker told you that she was going to be home alone by herself the day before she died? Chris Melton then tells law enforcement, I don't remember. So a question that you will have to ask, maybe a question that you will have, is if your future fiancée told you she was going to be by herself and died the next day, is that a fact that you will forget? You will also learn about the nature of their relationship. Dr. Lowe will tell you that Ms. Baker and Mr. Melton, first semester of law school, like this. They're really tight, really close. Mr. Melton will probably testify that if there are 7 days in a week, 5 of those days, him and Ms. Baker would be together. And this is first semester. But you will hear from Dr. Lowe that on New Year's Day of 2001, she came home, and to her surprise, Ms. Baker was home alone. And she talked to Ms. Baker about it, and she asked her about it. Ms. Baker gave a response. I won't get into that. But Dr. Lowe will say there was a change in the relationship from that day up until the time Tara had died. They were not spending as much time together as they used to. But you'll also hear from Ms. Baker's best friend. And I say best friend because Chris Melton stated, and that may be his testimony, that Mrs. Peavy Hall was Tara Baker's best friend. She described the relationship to law enforcement as it's pretty much like watching the normal ending of a relationship. But when law enforcement asked Mr. Melton about the relationship, Mr. Melton says, oh, everything was fine. She was my borderline fiancée when we were about to get married. It wasn't until 5 months later, in June, when law enforcement approached Mr. Melton and said, Chris, we heard about a fight that you and Tara had the week before her death. Do you know about that? And for the very first time, he admits that there was trouble in paradise. He says, oh, yeah, I know about that. It wasn't a big deal. It was something minor. Now, in the evidence that was provided to us, it wasn't provided to us. You'll learn that we don't have any information on what that fight was about except what Chris Melton said it was about. But it also matches up with Chris Melton's timeline. Chris Melton, when he interviewed with police in 2024, he told law enforcement that he had not seen Tara Baker in 10 days. Okay? That is a very important number. He said that I had not seen Tara Baker in 10 days. That 10 days lines up with their last fight when Chris Melton said, 5 months later, I remember this fight. That is an important date to remember. Because in 2001, when Chris Melton was asked, or matter of fact, he wasn't asked, Chris Melton was told that there was DNA evidence in this case in 2001. When they told him it was DNA evidence, Chris Melton volunteered, I was just with her 6 days ago. She was at my parents' house, and we had sex 6 days ago. And then he asked, did y'all find semen or anything on her like that? But this is the issue. Law enforcement failed to follow up. They met with Chris Melton's parents, and you would think it's a significant piece of information that you saw a young lady that died at your home the week before she died. The parents never mentioned or confirmed seeing Tara Baker at their home the weekend before. What's verified based on Chris Melton's own words, twice, 2024 and 2001. He saw her 10 days before she died, and they had a fight the week before, which will line up with that 10 days. I promised you that I would talk to you about Chris and Tara's relationship. So this was a relationship where these individuals met at Georgia Military College. Chris was in school as a pre-med major. So pre-med is pretty much when individuals are going to school to become doctors. Tara was Miss Baker was in school to become a lawyer. So these individuals were equally yoked when they met. Miss Baker graduated school, and of course, as you know, she entered law school. Mr. Melton dropped out of school. And what happened when Mr. Melton dropped out of school, Miss Baker, she moved to Athens to attend law school. And I'm sure Chris Melton knew he had an amazing woman. He followed. And he didn't follow and move in with Miss Baker. What he did, he followed and moved into a room of someone else that Miss Baker introduced him to. And you will learn that Mr. Melton, to stay close to Tara, was traveling back and forth every day for work from Athens to Covington, Loganville, Gwinnett County, Georgia, every single day while Miss Baker was attending law school. You will hear that towards the end of 2000, as I mentioned, that Ms. Baker was distancing herself from Mr. Melton, and she was developing a friendship with another individual, an individual that was in her profession. Her roommates will also tell you that the relationship with Mr. Melton was coming to an end. Now, this is the biggest thing I want you to focus on during the closing. During the evidence. It's Chris Melton's behavior after Ms. Baker died. This is going to be extremely telling evidence. Ms. Baker dies on January 19th. On January 25th, Mr. Melton goes to Miss P.D. Hall's home to spend the weekend with her and her boyfriend, the family. On the 25th, he calls a girl by the name of Lisa Tucker and invites her on a lunch. Now, let me change it. He goes on a lunch with her. I'll say that. He goes on a lunch. I don't want to misstate anything. We're talking within a week of his borderline fiance dying. took a lunch with her as well. And Miss P.D. Hall went to this lunch with Chris and Miss Holly Hufford, and she took her boyfriend at the time, Chris Hall. And what she'll tell you, or what the evidence will show, is that during that lunch, Miss P.D. Hall witnessed Mr. Melton flirting with Holly Hufford and even rubbing Miss Holly Hufford's back a week after his girlfriend has just died. And when Miss Ashley P.B. Hall says, all right, me and Chris are leaving, Chris Hall, her boyfriend is Chris Hall, me and Chris are leaving, Mr. Melton explained to them that he was going to stay and hang out with Miss Hubbard. And this, again, is within a week of his borderline fiance being brutally murdered. You'll learn on January 27th, after hanging out with Miss Hufford, he called her around 10 o'clock that night and told her if she was out on the town to give him a call. Again, this is a week after his girlfriend has just been brutally murdered. Miss Hufford did not give Mr. Melton a call back. You will also learn that there was a candlelight visual for the woman that Mr. Melton claimed that he loved. Death, you know, death is like this, losing it in instance. There was a candlelight visual held for Miss Baker. And instead of going to that candlelight visual for Miss Baker, for his girlfriend, Mr. Melton told law enforcement, because they had to confront him with this information. This is nothing that he told law enforcement. They confronted him with this information. Mr. Melton told law enforcement that, yeah, I knew about the candlelight visual. I knew about it for about 4 days. But, you know, Lauren, she already had these tickets to this country concert at Turner Field. And, you know, she told me that, she talked me out of going. She said that, you know, Chris, that isn't somewhere you need to be. So instead of going to his girlfriend's, if they were still together, his girlfriend's candlelight visual, he went to a country concert at Turner Field with 2 other couples. It was him and Laura Sherling. It was Laura Sherling's mom and dad. And it was also another guy and gal couple. You, the jurors, will have to decide if Chris Melton's actions after Miss Baker's death were consistent with someone who had suddenly lost their future wife. Next, I'd like to talk to you about law enforcement's failures. And there was a lot of failures in this case. During the trial, you will learn this case is not simply about my client, Mr. Faust. This case is not simply about Mr. Melton, nor is this case simply about Tara Baker. You will learn that this is a case of law enforcement neglect and failure. The evidence will show while this entire community was in dread and fear, law enforcement had enough evidence supporting that the person that killed Miss Baker was right in front of them. But because of the cameras, because of the media attention, and because of the sensationalism, they have Mr. Faust sitting in that chair. The evidence will show that law enforcement knew, this is information they're aware of, law enforcement knew and ignored, as I mentioned, that all the human hair found on her body that did not belong to Miss Baker was of Caucasian origin. You will not hear a shred of evidence that there's an African-American man's hair on Miss Baker's body. And the reason we showed you the photo of Mr. Faust with the afro is because he had a lot of hair. The evidence will show that law enforcement conducted a DNA test. A DNA test was done. This isn't the first DNA test. A DNA test was conducted on a pubic hair found on Miss Baker's butt. Now, in this case, and the state has already told you this, so I'll follow up with it. In this case, it is undisputed that Miss Baker was sexually assaulted anally. A piece of evidence that law enforcement had was a pubic hair was found on her buttocks. They conducted a mitochondrial DNA test on this hair. And the results of the test was that Mr. Melton could not be excluded as the contributor of the hair. This is information law enforcement had. Law enforcement knew, and this science is now not good science. I do want to be very clear with you. So we're not talking about it because of its scientific purposes. We're talking to you about it because they knew this information and ignored it. There was a hair found on the murder weapon, Ms. Baker's murder weapon. So on the cord that was used to strangle her, the cord block was next to Ms. Baker's head. I'm sure you'll see photographs of how Ms. Baker was found. On this block, they found hairs, human hairs. And one of the hairs, they did a test. It's not good science anymore. I want to make that clear. But at the time in 2001, law enforcement knew that that the scientists had determined that this hair was similar to Chris Melton's hair. And law enforcement ignored it. Law enforcement knew and ignored, and the state has already told you this, there was no evidence of forced entry in Ms. Baker's home. They talked about a window. This is what you will see in the evidence. Can we? This is the window that the state talked to you about. It's not the best picture, but what you'll see is there's a screen in this window. Because they could not figure out how the person got into the home, they started going around the house and they saw a bent screen. You will hear they saw a bent screen. And because the screen is bent and in the window, they assumed, hey, maybe this person broke in the house by taking the screen down, lifting up the window, lifting up the blinds, climbing into the window, committing this crime. Then, because the doors are locked, they climb back out the window, let the blinds down, close the window, then put the screen back in place. And I'll show you a closer picture of what you'll receive in evidence of that screen. That's a closer image of it. And this is one more image of that screen as well. And it's just showing the shape it was in when law enforcement saw this screen window. That's the outside. Now we're going to show you the inside, and this is what you'll see in evidence as well. This is the inside of that window. Chair in front of the window, blinds down, unruffled, but this is how they're alleging Mr. Falls entered into Ms. Baker's home and exited Ms. Baker's home to commit this crime. But law enforcement ignored that there was no signs of forced entry into her home. They ignored that both the front doors were deadbolt locked and the back doors were deadbolt locked. Law enforcement knew and ignored, and this is very important too, because Mr. Falls is charged with a burglary. Dr. Lowe will tell you that in her room, I think she had a change jar with money, she had jewelry in her room, she had electronics in her room, and nothing was touched. Nobody had even rambled through her room. You would also hear from Miss Ashley P.B. Hall, who will tell you, you may even see images, but you will learn that she had jewelry in her room and she had electronics in her room, and nothing was touched or taken. Nothing was rambled through. Then you will hear about Miss Baker's room. Miss Baker had heirloom jewelry in her room. Heirloom jewelry. She had diamond earrings in her ears. And the only thing that was taken is a personal item, which was her laptop. Police ignored that fact. Law enforcement also ignored, and well, let me say this. So we don't have to prove anything, right? We don't have to present any evidence. The state has to answer the questions when it comes to this case. There are no questions that we have to answer. But something that law enforcement knew and ignored was after Ms. Baker's death, a young lady volunteered. She called in to law enforcement and said, hey, I believe Ms. Baker was out at a Mexican restaurant with me the night before her death. This young lady's name is Jessica Gann. And we're either get it through Ms. Gann or we're get it through the law enforcement officer she told it to. But she said, hey, Ms. Baker was out with me the night before she died. She said, we're at a Mexican grill, and, I don't know if it's her, but I believe it was her. Blonde girl, she was talking about law school. I think I heard her. Law enforcement never followed up on this information. Law enforcement never showed Ms. Gann any type of photo of Ms. Baker. Law enforcement never followed up on her to figure out, okay, what more information do you have? They never even confirmed whether or not it was Ms. Baker she saw. They just ignored it. So the state cannot present evidence to you supporting that Ms. Baker, after she left the law library the night before she died, that she did not go out. They don't know. They don't know if Ms. Baker went out. They don't know if Ms. Baker went home. They just don't know. And they don't have any evidence to show one way or the other. Now, they mentioned Chris Melton's alibi. On January 21st, Chris Melton's parents told him, law enforcement, they are after you. They are coming for you, Chris. And that is a quote from Mr. Melton. That his parents told him, Chris, they are coming for you. This was January 19th to 21st, but it was in January 2001. Police wait 4 months to go speak to Mr. Melton's parents after they have already told him 4 months prior that they are coming for you. And mind you, Mr. Melton is staying with his parents now, so he's in the house every single day. They asked the parents, hey, can you tell us what your son was doing 4 months ago on January 19, 2001 at 7 o'clock in the morning? Can you give me a rundown? Surprisingly, and Chris Melton, you'll learn, is their only son, unless they've had children since then, but he was their only son at the time. They say, oh, he was at home. He was here. I remember seeing him. He was walking around. We were mulling around that morning. And then he left our house, and we know exactly where he went. How would they know that information? How would they know where Mr. Melton was going 4 months prior? But this is law enforcement confirming Mr. Melton's alibi, speaking to his parents. 4 months. 4 months after Ms. Baker's death. Law enforcement failed to verify Chris Melton's alibi thoroughly. They just started taking words for, oh, he was here? Okay, perfect. He was with you? Okay, perfect. And this is the important thing in this case. The most important time in this case is 7 a.m. to 9 a.m. Whatever happens after 9 a.m., it doesn't matter because the murder has taken place. So 7 a.m. to 9 a.m. Remember, Ms. Kashana Armstrong at 7:45 says she saw this guy running. 7 a.m. to 9 a.m. is the most important window in this case. Law enforcement also waited 4 months to try and get Mr. Melton's phone records. They waited 4 months after Ms. Baker's death to try to get the phone records for his apartment phone, and that may or may not be important to you all, but to get the records for his apartment phone and his parents' phone call records, resulting in those records being lost forever. So what the state will not be able to present to you in defense of Mr. Melton is that, hey, we have these phone records showing where he was. Those records were lost because law enforcement did not act to get those records. This is the most important thing. So they showed you all a map of Miss Baker's home at Cooper Road, and they showed you where Mr. Foss's home was located. Do y'all remember that? Seeing the box? Okay. This is what law enforcement, this is what you want here. They did a neighborhood canvas. They had a roadblock, all this great stuff. Things you want here. One, they did not talk to the residents on the other side of your apartment. They could have simply went to 350 Cooper Road and knocked on the door. And they would have had all the information they needed about Mr. Foss because, as they mentioned, 350 Cooper Road was his stepmother's home. So she could have gave them all the information they needed. Two, law enforcement was aware, because you will hear Ms. Dinkins say that, hey, I've looked at every document in this case. They were aware that Mr. Foss or his grandmother, if they notated, now I don't know how familiar their notes were, but those were not two individuals that were notated as individuals that they spoke to around the time of Ms. Baker's death. But this is a fear of theirs, because if they're saying that Mr. Foss stayed a block away, they're basing that on him saying, hey, I stayed at this address for a year. But again, they didn't go and interview those folks. They interviewed people in Deer Park, is what you'll learn, in the neighborhood that Ms. Baker stayed in. Chris Melton, another important fact. After Ms. Baker's death, Chris Melton comes to the police department with his hands covered in plumber's glue. You will hear from law enforcement that there was a shirt that Miss Ashley P.B. Hall, and she's an amazing friend, she did everything she could to try to figure out what was going on with Miss Baker. When Chris Melton came to her house, there was a shirt that she washed, and it was a substance. She called police and said, hey, we believe there's an issue with the shirt. And what law enforcement determined was the substance on the shirt was the exact same substance Chris Melton showed up to the police department with his hands covered in the day of her death. Now, you may hear the audio is grainy. I'm going to try to play it for you all. But you may hear law enforcement. I'm going to play it. So I have to play it a couple of times. But you'll hear law enforcement ask him, and this is a quote, do you want to wash them things? And Chris Melton says, no, this is neat right here. They never searched Chris Melton's apartment. They never searched Chris Melton's car for blood. There's a gentleman you'll hear about by the name of Lindsey Baker. He begged, you'll hear, he begged law enforcement, search his car. Did you search his car? Did you search his car? But what you will learn is, and the state already told you this, when Chris Melton came to Athens, he didn't bring his truck back. He rode in Josh's truck. And law enforcement never searched his car for blood. They didn't care. You won't hear evidence presented by the state that they searched Mr. Melton's car. You won't hear evidence by the state that they searched Mr. Melton's apartment. You won't hear evidence from the state that they searched Mr. Baker's parents' home. In regards to the claim that Mr. Melton made that he saw Ms. Baker 6 days before her death, law enforcement never attempted to confirm that. They just took his word for it. Parents didn't confirm it. No one confirmed it. They just simply, well, Chris said it, so it must mean it's true. Let's talk about the forensics. I've already talked to you about the hair. There is no, and I'm going to talk about this twice. When law enforcement met with, and the state told you this, when law enforcement met with Mr. Foss and they interviewed him, what they told Mr. Foss was that your DNA was found in a house in Deer Park. You will hear no evidence that Mr. Foss' DNA was found in any place other than Ms. Baker's body. His DNA was not in the house unless you're saying in the house because it's in Ms. Baker's body. But there's no DNA of Mr. Foss ever being present in that house. And you will hear he is adamant. I have never been to, I don't know anybody over there. He's going to say that. What law enforcement did not do, matter of fact, before I get into that, there are no handprints belonging to Mr. Foss. There are no fingerprints that the state will present to you belonging to Mr. Foss. There is nothing inside of the house that the state will be able to present to you to connect Mr. Foss with Miss Baker's house. The state wants you to believe that Mr. Foss is smart enough to enter Miss Baker's home, fight with Miss Baker, kill Miss Baker without leaving a trace of evidence behind, sexually assault her, right, because they're charging him with aggravated sodomy based on the allegation that he sexually assaulted Miss Baker anally, but sexually assaulted her without leaving any identifiable DNA behind, then escaped Deer Park just unseen, but he is dumb enough to leave his DNA in her body and commit the charged crimes at the busiest time of the morning. And I don't think the state ever told you what time they're alleging that Mr. Foss committed this crime. Their window is between 8 a.m. and probably around 8:45. And you don't leave your common sense at home. You know what's going on at 8 in the morning and 8:45 outside your neighborhoods. But you have to decide as the jurors, does that make sense? That's the question you have to answer. The DNA. I think this is the most important part of this case that I would like to talk about. We talked about the DNA test conducted on the pubic hair found on Ms. Baker's butt. But I would like to talk about the sexual assault kit that the state talked to you about. So the sexual assault kit, as the state explained to you, came back with multiple DNA profiles. Mr. Foss was one of the identifiable profiles. Mr. Melton was one of the identifiable profiles. Mr. Foss' DNA. If I understand the DNA correctly, and I may not, the testimony will be much clearer to me, was found in her vagina and her mouth. Chris Melton will tell you that Ms. Baker engaged in vaginal and oral sex. That is a very important fact in this case. However, as you know from the charges read in the indictment, Mr. Foss is charged with aggravated sodomy for anal sexual assault. Chris Melton told law enforcement when they asked him, do you all engage in anal sex? No, never. She doesn't do anything like that. You know, we just have normal sex. Well, lo and behold, when they get the DNA results back, the only identifiable profile in Ms. Baker's anus is Chris Melton's profile. Now, something the state mentioned, they told you in opening that gravity could make the DNA go into that area. Well, what the state says isn't evidence, but what Dr. Falzone says will be evidence. He is the medical examiner. He's the person that did the autopsy. And what he's going to tell you is that it is clear that Ms. Baker was sexually assaulted anally. Based on the injuries, well, let me use the right language. He's going to say it's consistent. That's the proper language. That her injuries to her anus are consistent with sexual assault anally. And the only identifiable DNA profile is Chris Melton's. The state will not present any evidence to you supporting that Mr. Foss ever engaged in anal sex with Ms. Baker. It is important that you focus on the evidence that is presented. He is charged with aggravated sodomy, and his DNA is not even identified in her anus. There is no evidence supporting that Mr. Foss had anal sex with Ms. Baker anytime or anywhere. The state will not be able to present evidence supporting that Mr. Foss and Ms. Baker engaged in that act. Now I would like to talk to you about what I call directing the investigation. You will learn that once law enforcement became aware of Mr. Melton's DNA in Ms. Baker's body, they learned that information that Chris Melton had previously told them was false. Okay? You heard the state tell you that DNA typically in certain places only lasts about 5 days. I left out a place. Mr. Melton's DNA was also found in her vagina as well. So his DNA was found in her vagina, anus. Mr. Foss' DNA was found in vagina and mouth. Okay? But you will learn that this DNA of Chris Melton's, as the state said, only lasts about 5 days. When law enforcement interviewed Chris Melton, they asked him when was the last time you saw her. He said 10 days, which I said was in line with their fight that he was approached about in June of 2001, the week before her death. Law enforcement says, well, look, and I want to make sure I say this correctly. Instead of interrogating Chris Melton and confronting him and saying, hey, you've been dishonest with us, something's not right here. We've seen the picture of your hands. What law enforcement tells Mr. Melton is they sit down and meet with him. And you're going to hear from the lead detective in this case, Elizabeth Bigham, that she asked Chris, and this is a quote, "So was there ever a time in those 10 days, leading up into her death, that y'all just had a quick booty call or met up real fast or anything like that?" Chris Melton responded, no. She knew what the DNA evidence was telling her. Ms. Bigham then tells Chris, "I need you to be 150% honest with me. And I know that what I'm about to ask you," and I emphasize this language, "is not what has been said for 23 years. And that may hinder you from wanting to be honest with me. But you've got to be honest with me." She then tells Chris Melton, "Look, your DNA would only last in her body 2 to 3 days. And that she needs to," and you'll hear this, "she needs to separate Chris Melton's DNA from bad guy's DNA." She says this. "I need to be able to explain it. I need to be able to explain it." Jeremy Howell tells Chris Melton, and you'll hear Jeremy Howell testify, that the timeline needs to be correct. Everything needs to make sense. And if we know that this window is here and you're over here, I can't explain this gap. You need to be here. But Chris Melton, and you have to decide if he sticks to his story because he knows he's lied before, continuously denies being with Miss Baker the week of her death. They asked Mr. Melton, "Well, were you with her the night before? You had a booty call with her at 12 o'clock? He says, no. They said, "Well, how about 2 days before?" No. "Well, how about 3 days, Mr. Melton? Were you with her 3 days before?" No. And eventually they get Mr. Melton for the first time to say in this interview, for 23 years, he changes his story to, "You know what? Well, we maybe did it on Sunday. We might have did it on Sunday." And then Elizabeth Bigham tells Chris Melton in this interview, not an interrogation, in an interview, "I think we just have to be able to explain it. I think we just have to be able to explain it. And that is our job, is to explain it. So we can then go after the one that we think did this." Laughs, she laughs. I mean, and the evidence will show Mr. Falls is the individual that she was referring to. My client. When Chris continues to refuse to put himself and Miss Baker together, Miss Bigham, she says, "If you're like, you know what, I effing lied about it 23 years ago because I was a scared, terrified kid, and you're right. I had a booty call with her that night. I left at midnight, and I don't know what happened after that. It'll be, thank you, have a nice day. We'll let you know what happens." Like, that's it. We just want to be able to explain it and make it make sense so we can focus on this, So they can focus on this. You'll learn the lead investigator in this case, Elizabeth Bigham, told Chris Melton it was okay if he changed his story or changed his timeline of when he was with Miss Baker. And if he admitted to lying to police for 23 years so that she could explain away his DNA and put the focus on Mr. Falls and the responsibility for Miss Baker's murder on Mr. Falls, everything would be okay. She would explain it away. When Mr. Melton would not help Miss Bigham explain away his DNA, despite the 23 years of conflicting statements from Mr. Melton, and evidence, and you have to decide, but evidence pointing away from Mr. Falls' involvement in this case, the allure of being a hero the allure of being on TV, being the officer to solve the 23-year-old Tara Baker case became too strong. And we ended up in the courtroom before 12 jurors to decide Mr. Foss's fate. The allure of being on TV became more powerful than following the evidence. And on May 9th, 2024, while Mr. Foss had just finished working, he's at Walmart buying a Simply Lemonade. Police cars swoop in on him and put him in handcuffs and arrest him. Solely because, and this is very important, and follow the state's timeline, solely because his DNA was present in Miss Baker's body. At the time of Mr. Foss's arrest, what you will learn, it's not, and this is, we told you, this is not a DNA case. We didn't come here to fight with DNA. You will learn Chris Melton's DNA is present, unidentified DNA is present, Mr. Foss's DNA is present, and based on his DNA being identified, he was arrested and charged with burglary based on DNA alone. He was arrested and charged with aggravated sodomy in the anus, even though his DNA isn't present. He was charged with 4 counts of felony murder. He was charged with malice murder, and every other count in this indictment solely based on his DNA being present, along with Chris Melton's DNA. Let's discuss the state's evidence against Mr. Foss, and I thank you for your patience. Do you all need a break? Let's discuss the state's evidence against Mr. Foss. To meet its burden of proof to establish beyond a reasonable doubt that Mr. Foss killed Ms. Baker, the state is going to rely on, they're going to present evidence of Mr. Foss's DNA being present. Okay? That isn't anything we're fighting with. As I told you, Mr. Foss's DNA profile was not the only DNA profile present, but these are the questions you have to answer, or the state has to answer. Mr. Foss' DNA profile being present does not tell you why this crime occurred or how this crime occurred. And you have to ask for that evidence. It does not tell you when the contact happened. And we don't know. It's been 24 years, 25 years. They've charged him with rape. They have to present the evidence that it was rape. The only thing that we could possibly say that you're here in the testimony in this case is that maybe when she was out at the Mexican restaurant, we don't know because they never followed up on it, they came into contact. We don't know. But that's a question the state has to answer. If you're saying it's rape, explain to us why his DNA is there. If you're saying it's rape, prove it. It does not tell us how the contact between Miss Baker and Mr. Foss took place.
I am going to object. If we can approach.
Ladies and gentlemen, we're going to have you go into the jury room for a few moments. Please don't discuss the case. We'll be with you shortly. Do you have a motion? Mr. Yelman-Cho.
Yes, Judge, because I think this relates to our ruling as to 412 evidence, which I just think Mr. Cruz violated in a manner that borders on placing him in contempt, quite frankly. Mr. Cruz just intimated about the possibility of prior consensual contact that resulted in Mr. Foss' DNA being present in Ms. Baker's body. outside of the complained of contact, which would be previous sexual contact that requires 412 notice, Your Honor. So I think Mr. Cruz has quite intentionally actually violated the court's order, which the court has made clear to him after multiple hearings on the issue. And so I'd like the court to instruct Mr. Cruz that that's, again, I guess for the third time now, that that's a wholly inappropriate suggestion to raise in any manner before the jury without having given notice, which he has repeatedly failed to do during the deadline set by the court, or from the point at which the court reiterated the fact that he had failed to procedurally give notice prior to today's date, which would be, well late of the time period in which he would have to do it. It would be 10 days late if he gave it today, but he has not. I would say further to the court that Mr. Cruz has represented to the court that he has no evidence other than what's in the state's file. Now, I guess he's making reference to this random tip that was received that Ms. Baker may or may not have been in a Mexican restaurant, which again doesn't say anything about her alleged contact with Mr. Faust. So there is no evidence supporting this, which is a finding the court would have to make, even if Mr. Cruz had provided proper notice, which he has not done, and now in opening statements after a week of jury selections has intentionally violated the court's order. So I'm asking the court to instruct Mr. Cruz not to engage in any further statements regarding that type of allegation, as the court has already instructed him, and to refrain from engaging in any questioning after opening statements, as is prohibited by Rule 412. So that's the state's objection, that Mr. Cruz has intentionally violated the rape shield law, and the instructions of the state is asking the court to give Mr. Cruz again for the third time.
In just a moment, sir. Yes, of course. Ms. Satterfield, are you able to read back the question prior to the objection? Are you able to do that? Would you mind reading that to the court? Thank you. Of course. unable to find it? If you can't, that's fine. I'll go ahead and ask the state for something. I'll let Mr. Cruz respond. If you can't find it, that's fine. I am going to go back on the record when you're ready. You good? Thank you for trying. Okay, thank you. Mr. Yalamanchili, please tell the court exactly what you feel, the words that you feel Mr. Cruz deliberately said to violate the order that the court gave.
Yes, Your Honor. So Mr. Cruz initially said the state can't prove when it is that Mr. Foss' DNA entered Ms. Baker's body. Mr. Cruz then said the police didn't follow up on this tip about the Mexican restaurant. Mr. Cruz then said it's the state's burden to prove that, and then said something to the effect of it could have gotten there when they had contact at that Mexican restaurant the night before the incident, essentially. Now, that's paraphrasing, but Mr. Cruz stated that there was a separate time when Mr. Foss could have had contact with Ms. Baker in a manner in which DNA would have been found in her mouth and in her vagina that is a match to Mr. Foss, which they are not contesting, Your Honor. So I think that is pretty clearly a violation of 24-4-412 when no prior notice has been made and no showing of competent evidence showing that would pass 403 examination has been presented to the court as required by 412. So that's the actions that I think that Mr. Cruz has taken in order to intentionally violate the court's previous instructions.
All right, thank you. Mr. Cruz.
So part of the state's case, Your Honor, is that Mr. Foss and Ms. Baker doesn't know each other at all. I was telling them that the only time, they could have had contact with each other at this restaurant. The court explicitly told me, or explained to me, orally, that I could not make an argument about consent. So I'm not making an argument about consent. A big part of their case is there's no way possible that these two even ran into each other. I'm just addressing that fact. Nothing in regards to the honorable court's order regarding court's will or in regards to argument of consent. Now, I am arguing, as the court has heard, that it's the state's burden to prove that a rape occurred. And that's as far as I understand that I can lawfully go, considering the honorable court's order to be not arguments.
Mr. Cruz, what would be the purpose of even mentioning the possibility of prior contact if it wasn't to violate the court's order?
Because the state's position is simply that these two would have never run into each other. We're disputing that fact.
All right, thank you. Yes, sir.
And, Your Honor, since it is my motion, that is a complete and total misrepresentation of what just happened. Mr. Cruz was talking about the DNA and the fact that the state's contention is that the DNA came into Ms. Baker's body when his client was raping, sodomizing, and then murdering Ms. Baker, and then said, alternatively, that could have happened if they had run into each other at this Mexican restaurant the night before in the context of where the DNA came from. So the idea that this is just an attack on the idea that Ms. Baker and Mr. Foss could have randomly run into each other in some other social setting and that it has nothing to do with intimating that there was some kind of prior consensual sexual contact, something that Mr. Cruz seems to want to create the impression of with, as he says it himself, no evidence existing to support, is a violation of 412. And I don't see how it could be possibly interpreted as anything other than an intentional act on Mr. Cruz's part after repeated instructions from the court that he hasn't followed the proper procedural rules in order to introduce such evidence, and his own statements that would support a finding by the court, even if he had given notice, that there isn't any evidence, much less sufficient evidence under 403 to allow that allegation into the trial of this case.
Thank you. Yes, sir. And Mr. Yelmenschley does get the last word. It's his motion, but go ahead.
I think the prosecutor's taking my statement and feel in gaps which conclusion he is reaching. Your Honor, if there's evidence in the case, if one of their positions is that, hey, these people would have never came into contact with each other, we're allowed to rebut the evidence by saying, hey, they never had contact with each other. I am not speaking of sexual contact. I am speaking of proximity. The state's position is just simply judge or object. We don't like it. I'll put it this way. For the state to get up and say, hey, this attorney should be held in contempt because he made statements about the DNA and saying that, hey, they could have had contact with each other. And I didn't say they had sex at the Mexican restaurant. All I'm doing is saying, hey, there's a chance that these two were around each other. I understand the honorable court's ruling, but to get up, object, and say, hey, this attorney should be held in contempt because he intentionally violated the court's order, that is not this. I have not said one time in this opening, consistent with the court's order, consistent with my understanding of 412, that Mr. Foss and Ms. Baker have had sex. What I've said is the state may be charging him with this offense, so they have to present evidence to support their allegations. And I've stated it multiple different ways, but that is exactly what the position is in our case.
Yes, sir. Anything else?
Your Honor, Mr. Cruz just said that it was about the DNA in his response. There is no other way to interpret DNA that is taken out of an oral sample and a vaginal sample that is male DNA other than claiming some sexual act. So I think not only is Mr. Cruz intentionally violating the court's previous orders, he's also being disingenuous in his representation of what just occurred in the courtroom, which the court saw for itself.
All right, thank you. That's all. All right, with regard to this particular moment, Mr. Cruz, we have had discussions about this issue. And I am finding that your comments were deliberate, that you are deliberately trying to circumvent 412. I'm not going to find you in contempt because this moment is very similar to an argument you made about the state's comments about a word that you did not agree was appropriate. Attorneys' comments, attorneys' arguments, openings and closings are not to be considered as evidence. But I am offering this to you, Mr. Cruz, as a warning that it is imperative that you follow the court's order. I've made several rulings with regard to this case. You are not allowed to talk about any issues of consent. You are not allowed to circumvent 412 without a proper motion. You have not filed a proper motion with regard to 412. If you do, the court will hear it. The state is correct. Even if we do hear a 412 motion, you have to have evidence supporting your motion. It can't just be something that you throw out there and assume that is something that could be properly admitted. But until a motion has been filed by the defense regarding 412, my order stands, and you are not allowed to go down that road. Am I clear about that, Mr. Cruz? All right, thank you. You may bring the jury back in. Thank you. All right, you all may be seated. Thank you. Mr. Cruz?
The state's evidence includes, we mentioned the DNA, but what they also intend to introduce, and this is the question you have to ask yourself with anything they introduce, how does this support that Mr. Falls is responsible for death, burglary, rape, and misbehavior? They intend to bring in a long-term girlfriend of Mr. Falls by the name of Miss Brenda Sweeney. Okay? Now, the thing is, Miss Sweeney and Mr. Falls were in a long-term relationship. They are not strangers. Okay? The state won't present any evidence of strangers coming in saying Mr. Foss broke in their house and did these terrible things to him. But what Ms. Sweeney will testify to, you may get 3 different things, because I believe we've gotten 2, okay? Police go to Ms. Sweeney's house when Mr. Foss is first arrested. The news is broke, right? She's getting phone calls. You'll see this if they present it. She's getting phone calls from people saying, hey, did you I don't know what I'm assuming. Pretty much she ends up saying that, I just got a phone call that Edric has been arrested. So what happens is law enforcement goes to her house, and the way they find her, based on what the officer says, is police reports. Mr. Foss and Ms. Sweeney have a tumultuous relationship. They fought a lot. Okay, there are police reports of Ms. Sweeney calling the police on Mr. Foss and saying he beat her up, and she gets arrested because there's witnesses saying no, it's the other way around. She was jumping on him. You're going to hear testimony from Ms. Sweeney where she says, hey, Edric hit me, and I beat him so bad I threw him into a DJ booth one time. Edric took my car without permission. I went to his grandmother's house, and I beat him so bad he was trying to get me off of him, so he was scratching me, and other people had to come take me off of him. And she's going to give you multiple stories like that. But during this interview, it gets to a point where you see that this interview stops. And she says, hey, the worst thing I can say that Mr. Foss has done to me, he's hit me, and when the relationship is over and I'm with somebody else, he'll stop. Won't leave me alone. Police don't take that as true. When they didn't get this scandalous story from Ms. Sweeney about how terrible of a person Mr. Foss is, and it's terrible to fight with your significant other, what they say is, Brenda, a young lady has been killed, and we want to get justice for this young lady. And we know, he's a terrible guy, and he's done terrible things to you. And just like we want to get justice for this young lady, we also want to get justice for you too. And she says, wait, guys, I don't know anything about a cold case. I don't know anything about a girl dying. All right, are you saying Edric did it? Yes, we believe he did it. And Brenda, you were involved. You were with him at the time. And you'll see her, she misinterprets it. She says, what? How am I involved? And he says, well, Brenda, you were with them, so forth and so on. We've seen police reports with you too. And then she pauses for a second, and she says, Edric used to force himself on me. And the officer says, oh, tell me more about that. Tell me more about it. And he says, did he punch you? She says, yeah, he punched me. Was he violent? Yeah, he was violent. When he would do this to you, was it vaginally, orally, anally? She said, or you'll hear, she says, I don't know, for me, vaginally. Right? And they continue talking to Ms. Sweeney. And it gets to a point, and they may present it, they may not present it. But I want you to know this is evidence that may come in this case. It gets to a point that Ms. Sweeney is under so much pressure. And forgive me, I've forgotten the piece. Ms. Sweeney tells law enforcement that she's had multiple strokes, by the way. So she's physically suffering, and she also says it affects her memory. But it gets to a point where they get Ms. Sweeney so worked up, she says, y'all, God just gave me something. She said, I'm very biblical. She said this one time, Edric went to this house, and there was this girl, and I don't know what he did, but he set the house on fire. And they say, well, did he hurt the girl? She says, I don't know. Says, was anything taken? She says, yeah, he probably took a TV. He probably took it to his stepmother's house. The officer asks, well, how do you know this? Did he tell you? She says, he must have told me. I knew too much. And police at that moment, they don't take it like, oh my goodness, she may not be in the best space to talk, right? They continue talking to her. She tells them all types of fantastical stories. But what ends up occurring is, once I find out about Ms. Sweeney's interview, and you will hear this too, that's why I say it's 2 sides. I speak to Ms. Sweeney. She comes to the court in front of the investigators that interviewed her, in front of the prosecutors, in front of Mr. Foss, in front of myself. And she says, I felt like they led me into those answers. She says the only thing that I can remember from my relationship with Mr. Foss is that there was one time that we had unconsensual sex. It was not violent. The state will introduce Ms. Sweeney not as evidence supporting that Mr. Foss committed these crimes against Ms. Baker, but to get you emotionally riled up. And that's why we chose you as jurors, because we believe that you will focus on the evidence. They are also going to bring in an individual by the name of Mr. Cedric Jeffries. Mr. Jeffries is serving a 105-month federal sentence. You will learn throughout this case, multiple people, since 2001, I know at least one officer has testified that there's been people from prison called with tips, like, hey, I have this information, can I get a deal or something? Now, what you'll learn in this case, Mr. Jeffries is going to testify that I don't have a deal. I don't have a deal. But what he will have to admit is that after he testifies in this case, he doesn't have a deal now, because it'll be terrible for him to have a deal now, because of course what we're talking about is deal. What happens after this case, after he testifies and says Mr. Foss told him in 2003 that he committed this crime, I'm going to get into the details for you. Federal prosecutors are going to meet with him. They're going to review the transcript. And if they determine that Mr. Jeffries assisted the state in this case, he is going to receive a benefit. Okay? And you have to consider that information in determining his credibility. But this is what he says. He speaks with, he sees the news. The news breaks of Mr. Foss's arrest. He's in jail. He says this, so you'll hear this. He admitted or we'll play a recording of it. He's sitting there watching the TV. He sees Mr. Foss get arrested. Okay? He doesn't call police. He doesn't say, hey, correctional officer, come here. I know something about a crime. He calls his lawyer. You'll hear that he reaches out to his lawyer. And of course, we don't know what the conversation is with his lawyer, but he ends up meeting with the lead investigator in this case, Miss Elizabeth Bigham. When he meets with Miss Bigham, she says, hey, tell me what you know about this case. He says, well, when I was 14 years old, Mr. Foss came to my house, and he was saying, oh my goodness, I'm about to get into it with police because they know that I killed this girl in Deer Park. Okay? That is what he's going to testify to. So police asked him, why did you wait 20-something years to say that? And Mr. Jeffries says the most important thing, and the reason why he's testifying in his trial. Mr. Jeffries tells him, jail helps me remember things. But you will hear from Mr. Jeffries. That is the state's evidence. Not a single shred of evidence will place Mr. Foss in Miss Baker's home. And the state has told you themselves, they've admitted it. We don't know how he got into the house. The evidence will show that Chris Melton admitted that Miss Baker had a key to his house. You have to decide if it's reasonable that Miss Baker...
I'm going to sustain that.
Yes, ma'am. But the state will rely on Cedric Jeffries, who, when he walks in this courtroom, he is serving a federal sentence right now, 104 months. And this isn't the first case Mr. Jeffries has testified on. Now, he may admit it, he may not admit it. But Mr. Jeffries, at this time, has testified on 2 other cases. He is a witness that gets in on cases and comes and testifies for the state. Something that's important, you're going to hear the interview of Mr. Jeffries, or he may admit it, so he may not get into the interview. But you're going to hear that Mr. Jeffries, one of the things he says is that I've never heard of this case before. Okay, and the state brought it to your attention that Mr. Foss stated that, in his interview, he made statements about Ms. Baker, and we're going to get into those statements. But before I get into those statements, I want to talk to you about sketches you'll see. The state is going to present sketches to you, okay? And what these sketches are of African-American men walking through Deer Park neighborhood, right? Police does a canvass after they find out about Ms. Baker's death. And during this canvass, they're talking to neighbors saying, hey, what did you see? The person that stays directly across the street, and Your Honor, may we switch back to the computer? Your Honor, Your Honor. So, thank you, Your Honor. So what you'll see, as I mentioned, the blue tarp, and I think you all have to be there, but the house with the blue tarp is Tara Baker's house. The house across the street, I believe that is Mr. Matthew Owens, Mr. Jay Anderson. I may be mistaken on this, but I think Matthew Owens definitely stays there, Mr. Jay Anderson, and another individual. And when police come and talk to them, what they're going to tell you is that we see a guy in a bright orange shirt. And as you know, in UGA country, you don't wear orange if you're trying to be hidden. But we see a guy in a bright orange shirt. He's either wearing khakis or jeans, and he was walking in front of, down the street in front of Miss Baker's house. And the officer asks, "Can you describe him?" He says, "Yeah, he has like small afro hair, black male, orange shirt, jeans." They said, "Well, how is he walking?" He says, "He's just walking regular, just walking." But he says, "I leave to go away. I walk away from the window for a second." He said, "It's maybe 5 or 10 seconds." He walks away from the window, and he says, "When I come back, that person is gone. I don't see him anymore." He said, "There's no way they could have made it to the end of the street because," he says, "I can see both sides of the street." He said the person had to cut through the houses. And then you'll hear from Miss Tiffany Riker. And that individual, I think it's Jay Anderson, but the evidence will show the proper name. He doesn't do a sketch, just to be clear. But you will hear from Miss Tiffany Riker, who stays right here, this house here. She's going to say when she's coming out of her house to get in her car, she also sees a black guy. And she gives the same description. Wearing an orange shirt, blue jeans, khakis. He's walking down the street. And that's the gentleman I said who, she backed up. She said, "You can stop for me to get out of my car." Now, what you'll learn in this case is on the other side of your park, there's another photo you'll see during this trial, there's a Walmart. It's the Walmart on Lexington Road. So people travel from this neighborhood up here at the top through Deer Park and around here, I think somewhere around here, you can cut through and go to the Walmart on Lexington Road. Okay? And Chris Melton will tell us that African-American foot traffic was coming. Tiffany Riker would tell us that she didn't think anything of it because African-American foot traffic is coming. She thought the guy was walking to Walmart. But when police get this information, despite Ms. Kashona Armstrong saying we saw a gentleman running through my backyard, police say, "Okay, let's do a sketch of this person." So you're going to see a sketch of a guy who may not even know his pictures involved in this case. But they're going to show those sketches. But they're also going to show a sketch from a young lady. She was the wife of a tow truck driver. Okay? And the state may, they may change it because I'm about to say it, but the state may try to make this one person. Okay? But it's two different people. She says, "Hey, I see a guy. Well, I was out with my husband. We were picking up a car. I saw a guy walking down the street." She says this guy has a heavy set face. He's kind of heavier looking. I can't really tell his body because of the jacket he has on. She says it's a bright jacket, but she says it's long sleeve, which is different from the individual that Ms. Riker and the individuals that stay across the street from Ms. Baker. Different from the individual they saw. They say, "Well, how was he acting?" She says, "Well, he was just walking down the street." She said, "I actually watched him in my mirror the entire time he walked, and he was just walking." They said, "Well, did he have on a hat?" "No hat, no hood, just a jacket, just walking down the street." The state is going to present those pictures to you as Mr. False. They're going to say, "Hey, it's a black guy in the neighborhood. This is Mr. False." But again, the only evidence they can present to you is that this gentleman was just walking. One, heavier set in the face. Another, wearing a short sleeve orange shirt. One wearing an orange jacket. All right? But those are the sketches they are going to present to you. One of the sketches, and it's up to you to decide, does not fit the description given at all. And you will hear evidence, you will see those sketches, you will hear the information given by those witnesses about what the person looks like. But the photo that I showed you, Mr. Foss with the hair, they're going to say, hey, this is Mr. Foss with his hair, and these are the sketches. Ask questions about the sketches. Look at the sketches. Listen to the information that the state gives you about the sketches. And just to make sure I'm clear, the person that was reported walking in front of Ms. Baker's house, our position would be this is the same person that Ms. Riker saw coming down this way, just for clarity. Lastly, you are going to hear Mr. Foss's interview. You're going to hear what Mr. Foss himself said about this case. You will learn, contrary to what the state has told you, that Mr. Foss was told when he was arrested, we're arresting you for murder and aggravated sodomy. They hadn't asked him anything. That's what you're here for. Murder and aggravated sodomy. Mr. Foss is confused. He talks to him. He chooses to talk to him wave his rights because, of course, he's trying to figure out what the heck is going on. While they're talking to Mr. Foss, they didn't tell him whose murder. You will hear Elizabeth Bigham and Jeremy Howell ask Mr. Foss, did you hear about a cold case from 23 years ago? And that's how they ask him. Did you hear about a cold case from 23 years ago? Mr. Foss tells him, I vaguely remember, and this is a paraphrase, not a quote, but I vaguely remember it. I think I saw something in the paper about it. You will learn Jeremy Howell nor Elizabeth Bigham show Mr. Foss a photo of Ms. Baker. Jeremy Howell nor Elizabeth Bigham tell Mr. Foss Ms. Baker's name. They don't say, the Tara Baker case. They just say, hey, you heard about the cold case from 23 years ago. They don't even give Mr. Foss the opportunity to explain the DNA because what they tell him, and this is very important stuff, they tell him, why is your DNA found in that house? Mr. Foss said, house? I've never been to a house in Deer Park. My DNA in the house? Your DNA is in the house. And just as much as I'm here to exonerate, I am here to hunt. But the truth is, as I've told you, the evidence will show there is not a shred of evidence putting Mr. Foss in the house. They didn't have that evidence, but they misled Mr. Foss, and of course hearing he's charged with murder and aggravated sodomy, he's probably freaking out, and he says, I don't know anything about the house. I don't know that woman. But again, they never gave him an opportunity to confirm who they were talking about. No name, no photo, just the cold case from 23 years ago in Deer Park, and your DNA was found in the house. What you're learning in this case, one person lied to police over and over and over and over and over again. One person simply said, I've never been to a house in Deer Park, whatever you're talking about, wherever you're talking about, I don't know. And the person that's in that chair is Mr. Foss. Now, Miss Baker, as we all know, is a very beautiful woman. They showed us a photo, or the photo that Mr. Foss would have been aware of. It's a glamour shot. The photo that you all saw was not a photo that was shown to Mr. Foss. I do predict that the state, they may change this, I predict that the state is going to attempt to play for you an audio version of Mr. Foss's interview. Because the video version will show that Mr. Foss was given no information other than that he was charged with murder and aggravated sodomy for a cold case that occurred 23 years ago. On the video, you will see no pictures shown to him, as I mentioned. The state's evidence may get you emotionally riled up, but those are not answers. I think this is significant for everybody to know. So in 2001, Mr. Melton is told, as I told you before, that Ms. Baker was sexually assaulted and they had DNA. I may not They told him in 2001, and that's when he came back with, I saw her 6 days before she passed away. When he was meeting with Elizabeth Bigham and Jeremy Howell, they told him, hey, we found another person's DNA in her body. And Mr. Melton's response was telling. Mr. Melton himself said, sounds like she was with someone else.
Objection again.
This is evidence in the case.
Ladies and gentlemen, I'm going to ask you to go into the jury room for one more moment. Please don't discuss the case. Walden, you have an objection?
I do, Your Honor. Mr. Yalamanchili and I had talked in anticipation of us getting to this point over the weekend that since I had made opening statement,
Pull that microphone towards you. Thank you.
that I would object since I had made the opening statement, but since Mr. Yalamanchili had made the 412 arguments in the past that he would handle.
All right, thank you. Go ahead, sir.
Your Honor, as the court's aware, as the state's aware, if Mr. Cruz wasn't aware before we started all the pretrial motions in this case, he ought to be aware now. Making reference, whether it's a statement made by some other witness, whether it's elicited direct examination, cross-examination, or any other method to a relationship between Ms. Baker and anyone else that was not noticed by the defense as a 412 act is prohibited by 24-4-412. I'm not sure how much clearer the statutory language could be, not sure how much clearer the court could possibly have been in its instructions, but whether it's Mr. Cruz making reference to a statement that some witness made during an interview with law enforcement, or whether it's Mr. Cruz eliciting the testimony on direct examination or cross-examination, it is all prohibited by the rule, which Mr. Cruz has violated now for the second time in his opening statement. It does not matter. It does not matter one bit whether or not Chris Melton said that in an interview to law enforcement for the analysis of whether or not it is admissible and the methods that must be adhered to if the defense intends to admit it in any way, shape, or form, Judge. And so this is the second time before we've called the first witness to the witness stand that Mr. Cruz has violated 412 in what seems at this point to be an intentional pattern to try to work his way around the laws and rules of the state of Georgia as it relates to admissible evidence in cases involving allegations of rape and aggravated sodomy, Your Honor. So again, at this point, I don't know what the remedy is that the court wants to enact, but obviously telling Mr. Cruz not to do it isn't effective because he's not listening and he's not following the court's orders.
Cruz. Any response?
Absolutely. I'm actually blown away and in shock that the state is taking this statement to be a 412 argument. Our theory of this case is that Chris Melton committed this crime. Chris Melton's statement, when he's confronted with DNA that he already knew was present, that she was with someone else, it has nothing to do with us trying to get around 412. That statement is for the sole purpose of showing his consciousness of guilt. He knew this information in 2001. He's told the exact same information in 2024. And his response isn't, oh, my girlfriend, I can't believe this happened, you guys better find her. His response is just simply to say, oh, well, must be me, she was with somebody else. There's no evidence that I intend to present that Chris Melton knows about Ms. Baker's sexual history. There's nothing I can intimate that Ms. Baker knows, that Mr. Melton knows about Ms. Baker's sexual history. The purpose of that statement has nothing to do with her character, under 24.412, her sexual character. The purpose of that statement is to show Chris Melton's response. When he's presented with some evidence, he gives a response that's inconsistent with the person that is innocent. So this isn't a 412. I understand the state may not like what I present, but that does not mean I have to preview every single statement I have to them so they can prepare their case. This is open statement show. I respect the court. I do anything for this court. I've told the court that multiple times. This is not a 412 argument. This is Chris Melton, who knows nothing about Ms. Baker's sexual history, being confronted with a piece of evidence and making a statement that shows consciousness of guilt in our court. This has nothing to do with sex.
All right, thank you. As this court has stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion, and I've said many times that if the defense files a 412 motion, even though it's not timely, the court will consider it. There has been no motion filed. Mr. Cruz, you've been made aware many times that you are not to bring in this kind of statement. I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking now, Mr. Cruz, thank you. You have been told many times that in order to present statements like that, ask for the admissibility of evidence like that, you have to file the proper motion. And the court may consider it even though it's not timely. As I just stated 10 minutes ago, I do find your statements to the jury to be avenues to circumvent 412. And it is not appropriate. I'm finding you in contempt of court. You have had the opportunity to explain yourself, and I'm fining you $1,000. And you are to present that $1,000 tomorrow morning by 9 a.m. Put it into the registry of the court. And that is my sanction for continuing to not abide by this court's orders. I don't know how many times we're going to have this, but it really can't happen again. $1,000 tomorrow morning by 9 o'clock. You may bring the jury up. Thank you. All right, you all may be seated. Thank you. Ladies and gentlemen, I want to remind you that any statements made by the attorneys, whether it is in opening statements or closing statements or during arguments, any statements by the attorneys are not to be considered as evidence. Mr. Cruz?
Thank you, Your Honor. At the end of this case, when you go back home, you're sitting around the dinner table, and someone says to you, "Why did you find Mr. Foss not guilty?" You're going to say, "Well, I was fed a wealth of information. All this information came, and it boiled down to one thing. The state couldn't prove that Edric Foss was the person that killed Tara Baker. The state could not prove or present evidence that Mr. False was in Ms. Baker's home. All of the hair found on and around Ms. Baker's body was Caucasian hair. Mr. False is an African-American man, and that's why we voted not guilty. The prosecution in a murder case is required to prove their case beyond and to the exclusion of every reasonable doubt. Not a forced doubt or a speculative doubt, but a reasonable doubt. They have to present a case from you from A to Z. If A is Mr. False's DNA and Z is law enforcement's investigation, they never answer the question at G, at H, at I, at J, K. They don't answer the questions about Chris Melvin. They don't answer the questions about the hair, even the hair found in her hand. If he did it, why would she have somebody else's hair in her hand? Why would she have non-African American hair in her hand? If Mr. False did it, how did he get in and out of the house unseen? Why didn't anybody see a black male running through the neighborhood? If he did it, why would he take so much time cleaning up her apartment? He doesn't know who stays there. There are 3 bedrooms. If he's a stranger, why would he take that time to clean her apartment? This was a crime opportunity. You all swore to uphold the law, to hold the state to its burden. There is evidence here of reasonable doubt that Mr. False did not kill Ms. Baker. And it is not just sprinkled through this case. Reasonable doubt lives in this case. When you all have heard the evidence in this case, we're going to ask you to render a verdict of not guilty. In this nightmare for Mr. False, I am asking you individually and as a body to find Mr. False not guilty. Thank you.
All right, thank you, counsel, for both parties. Ladies and gentlemen, we started a bit late today. It is certainly late. I am going to give you a lunch break, even though it is certainly late. I'm going to ask that you return here at 4 o'clock. We're going to try to get into a little bit of the case. I promised Dr. Waller that we would be gone by 5. I've kind of promised all of you that 5 o'clock is kind of our limit. There may be days where we go a little bit longer. There may be days where we go shorter. But I did promise Dr. Waller 5 o'clock today because I know he has an emergency at his house. So we're going to do that. But we're going to get into a little bit of the case at 4 o'clock. When you leave here today, please don't discuss the case, of course, with anyone. Do any independent research. Go to any of the locations you may have heard. Have a nice late lunch. We'll see you right back here at 4 o'clock. Thank you. Counsel, we'll see you at 4 o'clock.
Your Honor, and after the jury leaves, I wanted to raise a matter before the Honorable Court.
Sure. It's not? Okay, well, then we'll just go on the record then. All right.
I might know her, but very vaguely. She used to perform at Henry Shops when I worked there, like 10 years ago. But wouldn't impede my view of anything. I wanted to make sure that's not an issue.
First of all, Mr. Blankenship, Ms. Mooney, I absolutely appreciate you bringing that to our attention. Exactly what you should do. Let me just ask the attorneys, do you want to ask Mr. Blankenship any questions? Mr. Cruz? All right, thank you, sir. Have a nice lunch. We'll see you at 4 o'clock. Yes, sir. You can. Hang on just a moment. Mr. Terrell, anybody left in the jury room?
Oh, yeah.
You want to do it at the bench, or you want to? Okay. Y'all may be seated.